Yes.
Item 19, my lord.
19.
With consent of the appellant side, my lord. I seek 15 days time for filing affidavit, my lord.
IA is for
Item 19.
IA is
For delay continuance, there are two delay continuance for delay. One is for setting aside abatement and two IA as for delay continuance.
you are the applicant. You have to file objection.
Yes,
How much time?
15 days, my lord.
15 days.
Item 19.
Three HN Moria. When it comes for the opposite party.
Number 1.
Number 1. Please for submit that he would like to file an objection for which he has waited for some time. MS K. Borrower, Senate counsel for the opposite party, no, for the applicant. Appellant is present. List after
15 days.
list after 2 weeks to enable filing of such objection.
May I please, your lordship, beg to mention interstate case 2016 for listing, your lordship.
Of 2016.
Yes, sir.
When do you want?
9/8/2023,
9/8.
Wednesday.
And it will fix a lot of matters. Nonetheless, let it be 16 matters will try to.
9.
My lord, item number 5 and 6.
Yes.
Kindly adjourn for the day, my lord. On item number 5, we are from respondent, and item number 6, we are from the petitioner, my lord.
Who is for the other side?
I can consent the other.
You've taken the consent.
From the other side.
Uh,
On item number 6, interim is there, my lord.
in 6,
In 6.
7. A prayer for adjournment has been made on behalf of the RK Bhuya.
We are on item number 5, we are from respondent.
Okay, on behalf of the AK Purkas,
Okay.
on behalf of the AK Purkas, who learned counsel, who appeared for the respondent in CRP 100 of 2022 and for the petitioner in CRP 41 of 2022. Para. List after 1 week,
My lord, 2 weeks.
list after 2 weeks. Para, interim order, if any, can extend till the next date of this.
Blessment.
May I please, your lordship.
Yes.
Lordship, I'm praying for listing of an IA for orders, lordship.
I forward.
IA is for withdrawal of the 50% of the award, lordship. That was next week, lordship.
Next Wednesday.
Apply, lordship.
May I please, your lordship? I beg to mention IA 1933/23 for orders.
I for
In miscellaneous first appeal, lordship.
I for what?
On donation.
Delay condemnation.
The tribunal has kept that date,
The I is for delay condemnation.
delay condonation, lordship.
Is it coming for the first time or what?
It came on 28/7, but was left over. Then it was,
Has notice has been
then it
issued?
was left, date fixed on 1st August. But how the matter came up 1 day prior to the date of fixing. So on 31st is listed in the supplementary list. And we missed
No,
out.
has notice been issued?
Lordship, no, nothing has been.
And 31st, what orders were passed?
It was left over and fixed on 1st August. 1st of August.
And 1st August, what happened?
The case was listed on the prior, one day prior to the date of
That
listing,
is it.
31st. And
What happened on 31st? What orders
on
were
that day we
passed?
missed out, lordship. It was listed in the supplementary list, we missed the,
Then what orders were passed? You can-
after 2 weeks, but there is urgency in the matter, lordship. Since the lower court is keeping date
You can
after,
file an application. If there is a judicial order, that is why we are asking. After 2 weeks, that will amount to reviewing of the order. File an application, will allow it. File an application that because of these circumstances, matter had to be posted after 2 weeks. But there is
earlier also we filed petition, but
you have to file an application. Without application, we cannot review an order. That's a judicial order for listing of 2 weeks. At least there has to be something on record to prepone the date. File an application, will consider. Please.
May it
Yes.
please your lordship. Lordship, I beg to mention for listing of our IA today. filed in FAO. The FAO has been taken up yesterday and it was admitted. But your honor was not inclined to pass the status quo order as we didn't file inadvertently. We didn't file the stay petition
Has been filed today.
yesterday.
Is it ready?
Yes, Lordship.
Bring it.
Obliged. Lordship, I have another pair for listing of a civil revision petition.
When?
Next week, 9th of August.
Civil division of which year?
Lordship, fresh matter.
Press matter.
Obliged.
You bring it early as possible. As early as possible, your IE for status quo. It is in the FAO which is yesterday which is moved.
My pleasure. This petition filed by the husbandman seeking transfer of a divorce suit, my lord, instituted by wife beyond the jurisdiction, my lord, making false statement that she is residing, although she is residing under Nagaon.
Instituted where?
Instituted, my lord, page 13, it is instituted 22, my lord,
No, where?
Morigao. And she is a permanent resident of Chaparmukh area. This is under my lord Nagaon district. Paragraph 8 and 9, my main ground, my lord. 10 and 11 are the additional ground. Paragraph 8 and 9, these are the main ground. And 10 and 11, these are some other additional ground.
What are your main grounds? Paragraph?
8 and 9.
Yes.
And my lord, your lordship, kindly note one thing, my lord. I have in my cost title mentioned her correct address, my lord. Once your lordship, we should notice, my lord. It will automatically prove that she is the resident, my lord. I have not given the address, my lord. She has mentioned in her petition. that
Let us see the
Morigao.
petition. Let us see the petition.
Page
14.
14, my lord. Her address she has mentioned. Care of Rupon Hira, Mori Pachatia, Ward number 3, Post Office Morigao, PS Morigao, Mojam District.
Hmm.
And I have your lordship will kindly by page 2, post title. I have given her address, my lord. A resident of Station Road near Punjab National Bank, Chaparmukh branch, Post Office Chaparmukh, Police Station Roha, District Nagaon, Assam. I am a resident, my lord, of Landing. This is under judicial district of Hujai. Two son, my lord, completed their graduation. At this stage, my lord, she seeks divorce, dissolution of marriage. After 25 years of marriage, this petition has been filed.
Maybe we are not examining.
No,
marriage to
I am not only on the ground, my lord. That is,
The plaintiff is the dominant status. How can you say that the statement, we have examined the statement. He has not categorically stated that he is only living in the house of Rupan Hira. He says that
Her
she is
workplace.
living in the house of the parent of the petitioner as well as in the house of Rupan Hira. So he's got that much of restriction, and if you're questioning the jurisdiction, you can file an application for the court, not a case for transfer.
No, no, there is a, my lord, 25, 24, 5 categorically say this is the ground. Therefore, I have mentioned my 24, 5.
There's the 24 factor.
This is a ground, my lord.
Which ground? Lack of jurisdiction.
Yes.
But
A
lack
suit
of-
or proceeding may be transferred under this section from a court which has no jurisdiction to
No,
try.
that jurisdictions he has made out a case. You are disputing, that's a different matter. It has to be adjudicated. Whether she is residing at Murigaon for her work or not, that's a matter of fact. How can we decide? And we
There
cannot prevent a plaintiff from filing a suit.
2 other additional grounds also there, paragraph 9 and
What are the other grounds?
10 and 11.
Ten and 11 of- Ten. Ten is same.
11, my lord.
Murigaon will not 50 kilometers from there. You are the husband, you cannot take up this. So you will issue notice, you are not discussing. Will issue notice of this. But otherwise, I don't think it's a good case. Third, the AI Uddin, Senate Council for the petitioner who has filed this petition under section 24 of the CPC, read with Article 227 of the Constitution of India, whereby a prayer has been made for transfer of title suit within bracket D, case number 52 of 2022, instituted before the learned district judge Murigaon. Full stop. The state proceeding has been instituted under section 13 within bracket 1 within bracket small I small 1a bracket close bracket small 1b title of the Hindu Marriage Act 1955 for divorce by the second party wife. Full stop. The transfer has been sought to any competent court in Nagaon or Hujai. Full stop. Para. The principal ground of challenge is that the court at Murigaon does not have territorial jurisdiction as no cause of action has arisen. Full stop. He has, the learned counsel has further submitted that only to bring in the aspect of jurisdiction, comma, an incorrect statement has been made in the petition filed for divorce that the first party, within bracket respondent, is presently staying at Murigaon in course of her work. Para. No, para no. The learned counsel specifically has referred to the provision of section 24 within bracket 5 of the CPC. Full stop. Para. The ground raised for transfer is one which is mainly on the factual aspect. Full stop. Such aspect, whether such aspect can be determined or adjudicated by this court is itself debatable. So, para. Be that as it may, that notice be issued returnable on 1st of September. Let steps be taken for service of notice upon the sole respondent by usual process as well as by registered post. the prayer for interim order would be considered upon appearance of the party.
Till then, personal appearance, my, I may be allowed to throw advocate with. That part only.
Where is the requirement of personal appearance? The district court, not even a family court.
I am obliged.
We'll see what is their strength, then we'll consider your interim.
So that, since statute provided that, so once your lordship entered this application, that this, my humble submission would be, my lord, since it is an original jurisdiction, so 24/5, it can be examined.
Let us see what is our state after we come.
Applied.
May it please, your lordship. Okay, I have Salins order dated, lordship, 8/5/2023, passed by the learned civil judge Samrup. Page is 27. Lord.
27.
Yes, lordship. The operative part starts from page 31.
Just a minute.
Well, lordship, before,
Just
yes,
petitioner is the plaintiff.
yes,
You're the plaintiff. Should file for
should file for declaration and confirmation of position and for specific performance of contract.
declaration of right to influence, confirmation
Yes,
and specific performance.
yes, Lord.
Okay. Then what had happened?
Lordship, the fact is that I purchased 4 bighas of land.
For the fact, what had happened? To decree,
No, Lordship, it is pending.
suit is pending.
Suit
You
is
filed
pending.
injunction to be,
I filed injunction petition that was rejected. I challenged that order by filing appeal.
you file, first appeal presented. Then what happened?
Against the order of injunction,
Yes.
and it is dismissed. Against that, I am coming here. Against the order of dismissing the
First
injunction
appeal
appeal.
against rejection of injunction has also been dismissed.
Yes, Lord.
Okay, tell us.
Lordship, the fact is that I purchased 4 bighas of land in 2 different ducts by paying rupees 40,000 from the vendor. The vendor, in the name of giving a registered sale deed, they did not make register the sale deed. But there was some unregistered sale deed, and I am in possession of the agricultural land. And since the year 2000, I am making cultivation over the land. Suddenly, in the year 2015, the plaintiffs entered into agreement with the third party. I have made them party also in this case. And subsequently, after filing of the suit, they registered sale deed. The court below in injunction petition and also in the appeal came to a finding that I am not in possession of the land, and therefore
Now,
I
what
can-
agreement did you enter with the third party in 2015?
for sale of the land,
This land?
this land,
Okay.
and subsequently that was registered sale is also given. Their names were also muted.
Third party right.
Third party's name, and I made application for cancellation of mutation, and that there was a report that in that mutation case that I am in possession of the land, and therefore the
No,
authority.
unless you had a valid title by a registered sale deed, how did the title flow upon you? Upon you were the vendor.
Yes.
Who are the third party? So how
What's
did
it-
the right flow?
My case is for specific confirmation of contract also. I am asking them for registration of the sale deed
What kind of injunction were you praying for?
for not entering into the suit land by those persons. Because I am in possession, I am making cultivation over the land. That position should not be disturbed.
That will amount to a mandatory injunction.
Till disposal of the suit land. Disposal of the suit.
It will amount to a mandatory injunction. Let us see the discussion. Discussion of the trial court as well as the appellate court.
Trial court order is not annexed lordship here.
Right.
It was not the record. I did not get at the time of filing. Lordship, I shall file it by separate affidavit next week. Lordship.
Let us see the appellate court order.
Page 31, Lord.
31, yes.
Points for determination. Whether the impugned judgment and order dated 18/1/2018 passed by the learned trial court has suffered from any irregularity and needs interference in this appeal on the ground agitated by the appellant. Discussion, decision, and reasons thereof. I have heard Learned counsel for both the sides gone through the impugned order dated 11/8/2016 passed by the learned Munsif Kamru Amingo in VJ case number 95/2015 and TS 90/2050 and materials available on record. Before proceeding further to decide the matter on its merit, let me peruse the ratio laid down by the Honorable Apex Court of India in the case of Wonder Limited and another versus Antox India Private Limited. In this case, it was held the appeals before the division bench were against the exercise of discretion by the single judge. In such appeal, the appellate court will not interfere with the exercise of discretion of the court of first instance and substitute its discretion.
Is this you can keep Wonder and Talks, you can skip.
Yes. Then in
Thereafter also you can skip Radhabari,
yes,
then come to a discussion. 12,
keeping the above law in mind, para 12, Lordship,
12, yes.
in mind, and the fact that in the matter in hand, I am exercising the power of appellate court, which are very limited in nature, to set aside reverse the order of temporary injunction as sought by the appellant. It may have to be shown.
It must. It may not, it may, it must have. been. Not me.
must have to be shown with full satisfaction that the trial court used its power of granting temporary injunction arbitrarily, capriciously, or purposely, and or that the trial court has ignored the settled principle of law regarding grant of temporary injunction or interlocutory injunction. Now let us understand injunction before dealing with the matter in appeal. Object of temporary injunction. The object of temporary injunction is to protect the plaintiff against injury by violation of right for which he could not be adequately compensated in damages recoverable in action if the uncertainty were resolved in his favor at the trial. Now, ingredients. It is well settled that the grant of temporary injunction, three factors have to be satisfied, which are prima facie case, balance of confidence, and irreparable loss. In Dalpat Kumar versus Prahlad Singh, Honorable Apex Court explained these three factors as follows. There is a serious disputed question.
You come to the, you can skip that those portion. You come to paragraph 14.
Yes. The trial court in paragraph number 7 of order observed that after going through the case record, I find that the plaintiff failed to substantiate his claim over the suit land by adducing reliable piece of evidence. The plaintiff further failed to show the evidence existence of other ingredients for granting temporary injunction, that is balance of convenience and irreparable loss in favor of his case, as because the suit land are in the possession of the defendant number 4, 5, and 6. This is wrong. So where from the finding has come, it is not found. Lord. Considering all the instant petition, is hereby rejected. The status quo order passed earlier as regards the suit land is hereby vacated. Now, from what we discussed above, it is evident that at present, the defendants are in the possession of the suit land. The Honorable Supreme Court in MS Ramesh Chandra Jamna and Das and Company versus State of Andhra Pradesh reported in so observed that while the plaintiff was not in first possession of the premises in question, the grant of temporary injunction is not warranted. I am of consideration that the trial court rightly decided the petition filed by plaintiff under order 10 rule 1 and 2, rule 2, section 150 of the petition. Lordship may come to annexure C1.
Okay.
Next page, 36. 37 is the report of the 36 is the report of the Black Mondal. 37 is the vernacular. The applicant Sri Prafulla Sharma, son of late Mohendra Sharma, is a resident of village boundary under Mauda, Paschim Bangsar. The applicant has prayed for cancellation of invitation made by first of purchase on 21/2004 in respect of total land measuring 4 bigha, that is land measuring 3 bigha out of total land measuring 4 bigha, 4 kothas covered by diagram number 110 of patta number 120 and land measuring 1 bigha out of total land measuring 1 bigha, 4 kotha 3 hectares covered by diagram number 107 of patta number 121 of both of village number 1 Halugao under the aforementioned Mauda. The said land is being enjoyed by the applicant for last 15-20 years after purchasing the same. But due to several inconveniences, the plaintiff has not been able to mutate the said land in his name and on after executing a registered deed. It has been noticed that on 27/1/14, Sri Jagannath Kolita, Sri Vishnu Kolita, and Sri Tilak Kolita, all are sons of Sri Krishna Kolita, have mutated their names against the said land by virtue of purchase. This report says that I am in possession of the land. And
What
then
is your name? Prafulla Sharma.
Prafulla Sharma.
But it has been noticed last line that on 27/1/14,
Yes,
3 persons, son of so and so, have mutated their names against the state by virtue of purchase.
yes, Lordship.
If they have purchased, how are you possessed?
Lordship, that I purchased it much prior to their purchase, Lordship. Since 2004, there was an
No, no,
unregistered,
these 3 persons,
yes,
they have purchased from whom?
from my vendor.
Your vendor.
Yes.
By a registered sale deed.
By registered sale.
Difficult. When did you institute the suit?
2015, Lord.
And you said that you had entered into the land when?
In the year 2000. Since 2000, I am cultivating over that land, Lord.
Don't you think that you should have come to the court immediately for specific performance? Your suit for specific performance is in fact delayed. And these matters are all of discretion. Until such discretion has been exercised without following the due process, it is difficult for us to interfere. What explanation do you have for not filing the suit immediately?
No, Lordship. In the year 2014, the agreement was executed. And in 2015, I have come because I was of the view that I can continue in this land. But since they have,
No, the one person has got a registered sale deed, and another person has got a deed which is not registered.
Yes.
Law will obviously tilt towards the registered sale deed. Your assertion that you are in possession, that will be decided in due course of time, but giving an order, passing an order of status quo would not be justified. I think both the courts have rightly held. Not a fit case.
Lordship, you kindly see my prayers in the plain, Lordship. Page
Not a
22.
fit case, and that too under 226, 227 revision jurisdiction.
Lordship, it is under 115.
115, can you?
Yes.
Can you? 115, the amendment made in the year 2000, which 1999 amendment will be against you. If the order was decided in your favor, would the suit have come to completion? No.
True, Lordship.
And if you are invoking 115, if you say that 115 is there, you cannot invoke 227. Virudnagar has made it categorically, made it categorical. If there are provisions in the code, you cannot invoke 227 jurisdiction.
Yes, yes.
Not a quick case. But
Lordship, may kindly see my prayer in the plain.
we have heard our term learned counsel for the petitioner who has filed this petition under Article 227 of the Constitution of India, read with Section 115 of the CPC. The grievance of the petitioner is against a judgment and order dated 8/5/2023, passed in Miss Appeal number 5 of 2017 by the learned civil judge Kamrup, whereby the appeal filed under order 43, rule 1, within bracket R of the CPC has been dismissed. And the order of the learned trial court passed in the injunction application has been affirmed. Full stop. Para. The facts projected is that the petitioner, as plaintiff, had instituted title suit number 90 of 2015 before the learned court of the
Munsif.
Munsif which Kamrup
Yes, at Amingaon.
for declaration of right title and interest, confirmation of possession and specific performance. Full stop. Along with the state suit, mistake is number 95 of 2015 under Order 39, Rule 1 and 2 was filed for injunction. Though initially, an interim injunction in the form of status quo was passed, by the order dated 11/8/2016, the state application has been rejected and the order of status quo has been vacated. And again, such rejection, the appeal was preferred before the learned civil judge Kamrup, which was registered as Miss Appeal 5 of 2017. The learned council has submitted that the findings arrived at by the learned trial court as well as the first appellate court regarding possession is perverse, and in this regard, he has relied upon a report by the who is this?
Ratmandal.
By the Ratmandal dated 2/4/2015, whereby from which it appears that possession was with the appellant, petitioner plaintiff. It is also submitted that since the year 2000, the petitioner is in possession of the land and is cultivating the same. However, taking advantage that the sale deed made by his vendor was not registered, in the year 2014, the same land was sold to third parties by the vendor by registered sale deed, which is the subject matter of the suit. Full stop. Para. On perusal of at the outset, this court is of the opinion that a petition for revision cannot be filed by invoking both the constitutional provision under Article 227 and Section 115 of the CPC parallelly. After the amendment of the CPC made in the year 1999, the powers to be exercised under Section 115 has been restricted, and only upon fulfillment of certain conditions, such powers can be exercised, which are mainly for the purpose to have a supervision over the subordinate court. Para. Apart from the state amendment has also incorporated that further, the Honorable Supreme Court in the case of Virud Nagar versus Toronto has specifically laid down that whenever the provisions under the code COD is available, constitutional provision cannot be invoked. The relevant paragraph is expected herein below. Sir, be that as it may, even printing the application under to be one under Article 227 of the Constitution of India, comma, this court is required to examine whether the discretion granted invested in the court while considering an application for injunction has been done by following the due process of law. Full stop. Para. The impugned judgment dated dated
8/5,
8/5/2023
23.
passed by the learned First Appellate Court has elaborate discussed the facts and circumstances under which the injunction petition was rejected. The state court has also taken into account the law holding the field, and there is discussion of the case law of the Honorable Supreme Court in the case of Wonder versus Antox, reported in 1990 supplementary SCC 727, and also a decision of this court. The appellate court has also come to a finding that the trial court has exercised such powers by due care and attention, and there does not appear to be any arbitrary or capricious exercise of power. The law as laid down in the case of Wonder versus Antox Supra, and also reiterated in the case of Ramdev Food versus reported is that an appellate court should be circumspect in exercising jurisdiction in matters concerning grant, public non-grant of injunction, and such orders are to be interfered only when there is blatant error or perverse finding, which however does not appear to be present in the to be there in the present case. Full stop. The approach of the learned First Appellate Court appears to be in tune with the law laid down by the Honorable, with the settled law regarding such powers to be exercised by the appellate. Para. As indicated above, the powers of a revisional court is also restricted and only upon restricted and supervisory in nature, and only when a case of jurisdictional error or gross illegality is made out, interference is not liable to, interference is not warranted. In view of the above, the interpretation. I was provided
For interim injunction.
in view of the final order passed. CIA.
Obey laws.
May I please, your Lordship?
Yes, sir.
Lordship, the respondents and along with others filed a partition suit that was decreed. Thereafter, Lordship, they filed execution petition, and in that execution proceeding, their counsel filed an application. Kindly see, Lordship, page 61.
Defendant file partition.
different respondent hearing, file partition.
I am respondent to file for UOD.
I am I was pro forma defendant.
Formal defendant.
Later on, I contested and deemed to be defendant, Lordship.
Suit for partition.
Suit for partition. And partition was, the suit was decreed, Lordship, kindly have a look. At page 42. Paragraph 18.
Yes.
In the result, the suit is decreed on contest. The plaintiffs are declared to be entitled to 1/4 share of the suit land and house. The remaining defendants are entitled for the remaining share. The defendants are directed not to erect any sort of constructions over the suit land until the land is duly partitioned. The defendants are further directed to demolish the constructions, if any, erected so far. The district collector is directed to make the partition of the suit land in metes and bounds in accordance with this order and report compliance to this court. Let a precept be issued, the parties shall bear their own cost. Accordingly, Lordship, preliminary decree was prepared. The preliminary decree, Lordship, kindly see page 47. The operative portion, Lordship. Typed copy, page 47.
Yes.
It is ordered that the suit is decreed on contest without cost. The plaintiffs are declared to be
Yes, I have
entitled,
read this. Yes.
Lordship. Thereafter, they filed execution petition.
Hmm.
Lordship, here I would like to mention one thing. The decree was passed again in favor of 9 plaintiffs, but the execution filed only 6 plaintiffs. Thereafter, Lordship, execution proceeding was proceeded, and in that proceeding, Lordship, page 61. Kindly see.
6-1.
61.
Yeah.
The counsel for the decree holder, Lordship, filed an application. There is no signature of any decree holder, Lordship. Can you see the page 61? And there was no any affidavit also. And verification was signed by their counsel. The petition was, Lordship, is that the decree holder is required to use one JCB to dismantling the premises and structures standing on the land under decree at the time of delivery of khas and vacant possession of the land by civil nozil. They prayed for using a JCB, your Lordship.
Yes.
And accordingly, Lordship, page 65.
Five.
The order passed upon that application for using JCB.
Allowed.
Allowed, Lordship, some limitation was there. Kindly see paragraph 1, 2, 3, 4, Lordship.
This order is 15-6.
15.6, Lordship.
Yes. What has been ordered?
Paragraph 4, Lordship.
Yes.
Heard the learned counsel for the decree holder, considering all the prayer is allowed, but the use of JCB shall be confined only on the portion of the land which is decreed in favor of the decree holder. It shall not go beyond that limit. Furthermore, it is also made clear that the bailiff of the court, civil nozil, shall decide on the spot whether the JCB can be used on the decreed land of the decree holder without causing any damage to the other structure beyond that land. Then only he would take the JCB in use on the land decreed to the decree holder.
Correct.
Thereafter, Lordship, the case was fixed for submission of report.
Correct.
What happened, Lordship? After getting that order, the decree holder did not pursue, Lordship, until the decree holder was also absent in that execution proceeding, and Lordship, For their absence, this execution was filed. Page 75, Lordship, kindly see, till 2022,
Page,
page 75.
date,
Date order dated 22/3/2022. 75. Decree holder is absent. On perusal of the case record, it appears that the decree holder filed the execution case on 11/5/2015. But since 3/2/2021, decree holder is
No, you
absent.
say that on this order for use of JCB.
That order
order-
was passed for use of JCB, Lordship,
That was of the year 2018.
2018.
Now they have
They did not proceed with their execution proceeding, Lordship.
their default has started from when?
Since 2021, Lordship.
Since 2021. What has happened between 18 to 21?
Lordship, in between COVID period was there also. And I have annexed,
Was that JCB order executed? No.
no, Lordship. No, that order was not executed. But when they,
Okay, then
then Lordship, the file, thereafter, Lordship, that next page, page 76, Lordship.
Hmm.
On that day, the decree holder appeared and filed petition, and that petition was allowed. And as because the case was filed since 21, Lordship, the executing court issued fresh notice to the judgment debtors and fixed the execution case for filing show cause.
yes, then
The order show cause, and in between some of the parties died, and the petition the court allowed to directed to substitute the parties, and the case at the stage at present the case is at the stage of filing of show cause and substitution. But on the behest of that earlier order of 18, the decree holder now trying to use the JCB, Lordship.
where is it?
I have
Which order?
stated that no order is there, Lordship.
Yeah.
But they are trying, Lordship. I have specifically stated that part, Lordship.
Which order are you challenging there?
That 18 order,
Which order
JCB.
has spent its course? The order of 15/6/2018 has spent its course.
But now, Lordship, the case
Unless
is,
the order is renewed or a fresh date given, you don't have a cause of action with this present allegation. You can have, but it is not for a court. Revisional court will only go by the orders of the court. There has to be an order by which some action will be taken for execution. This 18 order at 2023 August, can it be put to, can it be acted upon?
Lordship, now they are trying. So, Lordship, this
Have you
petition has
filed a petition for the court? You filed a petition
before the trial.
in
Lordship.
the court that there is no order as such. 18 order has become honest now.
That may be observed, Lordship, in my petition. I'll file the appropriate application here, Lordship.
Wrong conception. Not a fight. I heard 3 AR no standard concept for the petitioner who has filed this petition under Article 227 of the Constitution of India. Challenging an order dated 15/6/2018 passed by the Learned Munshi from Dibrugarh in title execution case number 12 of 2015. The fact projected is that the petitioner was initiating the pro forma defendant in a suit being titled to number
92 of 2010.
92 of 2010 instituted for partition. Full stop. To resume, the learned counsel, however, at the outset has clarified that when the petitioner, that subsequent, since the petitioner had contested the suit, he was treated as a principal defendant.
Lordship,
Full stop. It appears that the suit for partition was decreed with certain direction and execution was started. Full stop. The learned counsel has referred to a petition filed by the council praying for such direct in which the learned executing court had passed an order dated 15/6/2018. Full stop. Though the prayer was to permit use of a JCB for demolish certain structures on the portion occupied by the defendant, comma, the learned executive court, while allowing the petition, had allowed such use under certain restrictions and on the supervision of the bailiff of the court. Full stop. It is however submitted that the state order was not pursued and there was no demolition exercise. Full stop. It further appears that due to certain reasons, comma, the matter was not pursued at all by the decree holders, leading to passing of an order dated 22/3/2020
Lordship,
when the execution case was filed. Full stop. However, comma, it appears that thereafter the decree holders have appeared and accordingly on 27/4/2020, comma, fresh local notice has been issued. Notices have been issued. Full stop, para. To restore the learned counsel has, however, submitted that in the meantime, comma, there has been various developments, including death of certain parties, for which the decree holder has taken steps for substitution, etc., which are pending consideration. The apprehension, however, raised before this court is that taking the advantage of the order dated 15/6/2018, comma, the structure of the defendant over the suit land would be demolished. Full stop. Thereafter, this court is, however, of the opinion that the present petition is itself misconceived, inasmuch as the order by which restricted use of a JCB was permitted is of the year 2018, and in the meantime, almost more than 5 years have passed, and therefore, in absence of a fresh order, comma, fresh order and also taking into account the change in the circumstances, until a fresh order is passed for such demolition in for execution of the decree, the apprehension appears to be wholly unjustified and misconceived. Full stop. Para. In any case, the revisionary power of this court is a limited one and would be exercised only on dot. In view of the above, this court is of the opinion that the interpretation is not maintainable. Full stop. And according to the same is dismissed. Full stop. However, the petitioner is at liberty to file appropriate application before the executing court, raising the aforesaid gravamen, and in the event such application is filed, the state would be considered in accordance with it.
Lordship. Lordship, till disposal of my application, that order may not be executed, Lordship.
There is no scope. We have already said. In the first part, we have already said that the order has dropped is back to the court. Yes, next.
Oblige, Lord.
My lord, the respondent here had filed one title suit against the petitioner for eviction. And but my predecessor interest, my father-in-law was the tenant of the respondent. And after his death, I was running the business. And the respondent has filed the suit on the ground of defaulter and bona fide requirement. In order to, after examination of the evidence of PWs, I filed one application for calling of the Miss NJ cases record, and that was allowed. And I was directed to take steps. I have taken steps time to time, and
of which year?
suit is of 2020.
20. Yes.
And I filed one application, annexure 3, page 44, for calling of the Miss NJ case records with the documents.
Yes.
Which the regard pertaining to the Miss NJ cases.
Yes.
And had order dated annexure 5, page 58.
Yes.
Both sets are duly represented by their learned counsels.
You're
Peruse
referring
the
to
case.
18.5. You're referring to 18.5.
18.5 order.
Yes.
Peruse the case record. After perusal, it seems that the by order dated such and such has directed the defendant side to take steps for calling on NJ records, and such last opposition was given to them. It seems that since the matter was fixed for calling NJ record, and even on previous date they have defaulted in taking steps. The defendant side verbally stated that due to certain unavoidable circumstances they could not take steps on last date, and as such, I am of opinion that for the ends of justice, the chance may be given for calling of the NJ case records with a cost of rupees 500, which to be payable to the plaintiff. Also, in the court by order has seized the matter today for cross-examination, but on perusal of the case record, it is seen that the cross of the PW was already been conducted. As such, the court deems it fit for proceed the case towards the next stage, fix evidence for DW's calling of NJ case record. Accordingly, I have taken step, and requisition was issued in the left-hand side of the date order. It was reflected that the requisition was issued on 24/5/23 by memo number 288.
Hmm.
And the next date was fixed on 22/6. On 22/6, the Miss Jane's case record were not received. And the court waited till the late hour of the late hour and passed the order dated 22/6/23, whereby I was directed to take fresh steps. Reminder.
Yes.
But I was not able to verify the case record on that day, and subsequently I relied upon the e-court order which was uploaded in the e-court, and in page 61, your honors will find the e-court order.
Yes.
DW's NJ case record, business, next purpose, defense witness.
Yes.
Here it is from the perusal of the e-court order, I cannot ascertain the as to that I have asked to take the face reminders for calling of the NJ record. And on the next day, when I came to learn that I was directed to issue reminder, and on that day, I filed adjournment petition for DW and submitted the reminder, but that was not issued, and that calling of the NJ case record was rejected. Against that order on 6/7/23.
Yes.
Kindly peruse the order dated 6/7/23. Typed copy is page 62.
Yes.
Parties are on both sides are represented. Peruse the CR. Learned counsel for the defendant filed a petition number 7 praying for fixing another date for filing evidence and of defense witness. Prayer is allowed. Today is also fixed for NJ case record. Upon perusal of the CR, it appears that since 27/7/22, the suit is pending for NJ case record. On last occasion, and on 18/5, the defendants was given last chance to call the NJ case record, imposing cost of it. But even today, no NJ case record is received by this court, nor any steps was taken by the defendant on last occasion. That was due to the bona fide mistake on account of the non uploading the entire order of the court below in the e-courts. So I may be permitted to take steps in the NJ case record may be called for, because without the NJ case record I unable to prove my contention that I'm not a defaulter in payment of the rent.
See, the order was passed on 22/6/2023, when press steps were directed to be taken as the records were not received. Now you say that, let's see that order again at page 60.
Parties on both sides are represented.
See,
Peruse the CR
at it is at 60.
60.
60. Where is the type copy as 59?
Page 15.
The parties on both sides are represented.
Represented.
Peruse the case record.
Hmm.
Learned counsel for defendant side, that is you, filed the petition praying for keeping in abeyance the requirement of filing evidence on affidavit of the defendant if the NJ case record.
Hmm.
Whereas is rejected.
Hmm.
That is not the part of challenge.
Not changed.
NJ case records have not been received. Issue reminder.
Hmm.
Defendant is to take step. Cost of rupees so and so paid today. Same is given to the plaintiff. Fixed so and so for evidence of DW calling for NJ case. See, there are two parts here.
Yes, sir.
One is keeping the process in abeyance since the defendant witness, and second is with your prayer for calling for the NJ case record. The prayer in substantially was allowed on the earlier occasion on call. And you had taken steps, you showed the requisition. Now the record of NJ case was not received by the court. This order was interpreted on 22/6/2023. After hearing you take press step. You say that you had come to know about this order by the e-court order, which is not elaborated. Are you required to depend only on the e-court order? Number one. Number two, this order was passed interpreted in your presence, and you have not taken steps. And number three, the most important part, this is not the first time you have failed to take steps. The failure to take steps ended in a order by giving a last opportunity and that to a payment of a cost. After that, can we, as a revisional court, we find fault with the court orders of the trial court?
No, my lord, when there is a, on the earlier occasion when I have taken the steps, and based upon which, if the NJ case record were not received, the court may,
Did the court,
the trial court may ask the dealing assistant as to why he has not sent the case, and he has not sent any report also.
you have not challenged that order, that the
Well,
order,
no, my lord,
that order is erroneous.
You know,
You should not have directed to take press steps, rather the explanation should have been called for. You have accepted the order.
no, my lord, I
Your
have,
challenge is on a different context. You cannot change your shift your stand now.
no, my lord, and I, in my revision petition, I have stated about this, that the court may had ordered it.
Where is the challenge? Where is the challenge? You should have challenged this order. I am not required to take press steps. Is this order some palpably illegal order requiring you to take press steps? An explanation, your explanation that from the e-court uploading you could not know, that we are not going to accept. It's an interpreted order. You were present. You did not even bother to look at the order.
Oh my God.
Earlier occasion, how did you know about the order? All occasion, this is a suit of 2020, that's an eviction suit, eviction suit.
My lord, I may be permitted to challenge that order also. I may be. One date may be, I may be,
We are discussing this. You challenge, it will give you liberty.
my lord, I may be permitted to amend my application.
Amend this application. How can you amend? This is on a different context altogether. You file a separate one.
My lord, then I am withdrawing this and I may be permitted to file a fresh application.
Sri R.K. Moore, Senate Counsel, who by means of this application filed under Article 227 of the Constitution of India has put to challenge an order dated 6/7/2023 passed by the learned Munsif number 4, Kamrup Metro in title suit number 151 of 2020. By the said order, comma, the issue of calling for the case record of Ms. NJ case has been closed. However, after hearing at some time, comma, remove the learned counsel submit that he would like to withdraw this application. However, with liberty to make further challenge of challenge of certain other orders also. This court has not entered into the magistrate case while discussing this petition, comma, liberty has paid for this grant. In view of the final orders of dismiss the constitution, yes, next. Everyone has repeated.
My lord, in this appeal, we have challenged the part judgment Your Lordship, I'll take your Lordship to page 79.
Yes.
So for the decree of divorce, my lord, granted, this
You are
is
the-
not under
You are the
check.
wife,
I'm the husband, my lord.
you are the husband. That's the appellant. You are the opposite party.
I'm the appellant Bhupendra Kumar Das.
Who instituted the divorce?
Uh,
You.
Deepanjali Chetia, my lord,
You are the
the,
opposite party, second party.
no, I'm the first part,
You had instituted the
my
divorce.
lord. And that has been granted. Your Lordship will find that at paragraph 32.
Why are you agree with that?
My lord, I am agreed by the order, the respondent is awarded permanent alimony of 8 lakhs. Now that has been, my lord, assessed without considering the corresponding expenditure which the appellant incurred in a month. Now, if I take your lordship at paragraph 6, my income source that your lordship will find,
8 lakh permanent.
page,
alimony.
page 6, my lord,
This is permanent. Let us see that part.
beg your pardon.
Let us see that part.
Second part at page 79, para 33. Respondent is awarded permanent alimony of rupees 8 lakhs, which the petition is directed to pay directly in her bank account within 3 months. And my income per month is 64,000. And after the expenditure, my lord,
What do you do?
my lord, he is a businessman, but then since because of his ailment, he is a heart patient. He cannot do anything. He is dependent on his manager. Now, therefore,
Manager, you are not required to move around personally. The manager will do.
my lord,
You are a big businessman.
as your lordship understand, the manager, we cannot have.
What is your business?
This he is having a wine shop.
Oh.
And it is, my lord,
Are you required to run around?
No,
Not
no, my-
obviously.
my lord, the wording, this is the wine shop shows that it will have a very good income. In one point of time, he had. Now, after
Now it's
the,
better.
no, after the COVID period, this has gone down. The income tax, the return will show, my lord. I'll take
After
your,
COVID, it has increased.
my lord, so far.
People
he
have
is-
nothing to do. They were sitting at home. So
Your lordship is true
Only
in one
thing.
way. But what happened in this case, since he became ill, he cannot go. And off and on, he is in the hospital always. My lord.
what is your age?
He is, my lord, maybe around 40.
Issues?
No issue, my lord. And my lord, for his ailment,
8 lakh permanent, I don't think it's on a higher side.
my lord,
We'll give you installment.
ordinarily, my lord, I am with your lordship,
No, no,
what your
we'll-
lordship is saying.
We'll give you installment. More than 3 months. We'll increase this period.
My lord,
Don't tell me.
my lord, for the time being, my lord, can I,
If she comes for enhancement, you may be in difficulty. We are telling you that.
your lordship may be very true, my lord. I'm,
You
my
will
lord,
be difficult. So better to get this confirmed by the High Court. You can say at least High Court has considered.
my lord,
and put it in
can I, for the time being, my lord,
You take
say like this,
You
that
take instructions, we are going to dismiss this.
for the full, for the time being, 4 lakhs, your lordship may say, with giving certain installment. And then in the
4
meantime,
lakhs, you don't need installment.
that way, my lord, he
3
is
months is given.
not in a reason.
4 lakhs, your monthly income would be, I would not know.
My lord, if your lordship look at income tax return, the lordship will find that his position is not good at all. He was
You are
expanding,
not a salaried person. Your income tax return is highly doubtful.
my lord, only because since he is ailing, that's the problem.
Let us
Otherwise,
see your averments and documents of ailments,
yes, yes.
BP and diabetes,
Diabetes and heart patient, my lord.
everyone.
Uh,
Show us a single person who doesn't have BP. And
more or less nowadays, these are,
that
they
is
are-
not an ailment. That is a way of life. In fact, if you don't have BP, people will really be concerned. Why are you not doing BP?
one doctor told me once, if you are having diabetes, is a blessing in disguise. Then I asked him in what way. He said, then you'll control your diet, not take all the things whenever you feel like. So, but then he's not only having diabetes, but he's suffering from heart ailment.
Let us see your Apollo Hospital document. starting from page 40.
That your lordship will, my lord, the document starts from page
Let us for 43.
31 onwards.
43 is the money receipt. Let us see your HB one.
International Hospital at page 37. These are all, my lord, prescription. Then
Blood count. Hemoglobin is 15, excellent. Creatinine 1.22, what else do you need? Liver functions excellent.
1.22 in the higher side. I
No, no,
believe.
not at all. Glucose fasting is 73. Lipid 169. PSA is 4.38. What else?
These ailments are there.
These are no ailments. Show us a single parameter, a single finding of the in the pathology report.
Those reports that we have in the next.
Your petition, you have an certain report. We give you installment.
7 months.
Huh? We give you installment. Instead of 3 months, we'll make it slightly more, maybe 4 months.
But,
Eight
can I,
lakhs-
my lord, can I get instruction?
8
from you?
lakhs is not much nowadays, you know.
No,
on a
my lord,
serious-
I understand your
on a
lordship's
serious
feeling.
note. And she has said in Facebook that she is a working woman. That itself will not be enough.
Yes.
Let us be reasonable. 8 lakhs is not much.
Your lordship is very true, my lord. I also endorse that.
And let us put this to an end.
My lord, your lordship may keep it parted. Let it come on Monday so that I can get.
Okay,
instruction.
Monday will.
Right.
Heard, Priyas Dr. Lanet Senior Counsel for the petition, for the appellant, who by means of this appeal has put to challenge a part of the judgment dated 12/4/2023 passed by the learned district judge Dibrugarh in title suit between bracket divorce 35 of 2017. Para, the appellant was the petitioner who had instituted who had instituted the proceeding under section 13 between bracket 1 bracket close between bracket small 1 side of the Hindu Marriage Act for dissolution of marriage. Sarah, the senior counsel has submitted that though the divorce has been granted, the grievance is with regard directed regarding payment of alimony, which has been stipulated at rupees 8 lakh. Regard the permanent action, which is stipulated as rupees 8 lakh to be paid within a period of 3 months. Also, Sarah, the case of the petition is that there was no proper assessment of the relevant factors, including the income and the expenditures incurred by the petitioner on himself due to his ailment. Also, Sarah, this court, after hearing the Senate counsel and also after perusing of the materials of record, is of the prima facie opinion that the amount involved may not be on the higher side, more so taking into account represent the situation. Full stop. The business of the petitioner has also been taken note of. So that this is from senior counsel have subject that he may be granted some time to have instruction. Sarah, in the interest of justice, comma, that this matter be adjourned for today and direct petition on Tuesday next.
Right.
Have one more Tuesday next, on which it, after receipt of instructions from this court, will pass final orders.
Obliged.
But advise your client. I think not a case for
Truly, my lord, I am having the same view as your lordship.
it is not too much.
Obliged.
May it please your lordship.
Yes,
Lordship, I have preferred this appeal
appeal has
against,
been admitted.
appeal is admitted, my lord. And in last occasion,
LCR
LCR
has
has
come.
been, yes,
Yes.
LCR has been received. My
Step.
lord, here, in this case, my lord, I have challenging the impugned
Step.
steps. On last occasion, the council was there, my lord.
Somebody has
And-
appeared.
Yes, my lord.
Who has appeared?
As per order dated 16/6/2023. My lord,
It's been six, your-
in the order, it is reflected that both sides were present, my lord.
There's no name of it.
And a notice was there, my
Your
lord.
lordship, this has come for the first time. I am appearing.
No.
You'd be appearing.
Yes.
Who's for the other side? You're for who?
Railway,
Huh?
railway.
You're for the railways. Okay. Then we'll directly restoring on name. Has anybody's name been reflected in the call sheet? Madam is
No,
standing on the railways there.
yes, your lord. Nowadays,
CDC.
Okay. Then we can have this for hearing in its turn.
Lordship, it will be fixed in the admission column, admission hearing, because,
No, it's been admitted. Already
because
done.
my lord, urgency is there, my lord.
No,
It's
for
a
that we can fix-
circular based matter, my lord.
For that, we can fix the date for hearing, but the matter has already been admitted. So the question of admission is not arise again.
Then my
What is
lord,
the
urgency is, my lord, because the claimant who is the owner of the goods, my lord, he has invested a huge amount in this case, my lord.
what was the appeal for?
The claim is for the refund of additional freight which was collected by the railways. And my lord, here the contention of the appellant is that he has booked a consignment of iodized salt, my lord. And iodized salt from Chirai, my lord. It falls under the Western Railway, my lord, within the jurisdiction of Western Railway.
Where is Kirai?
Chirai is in Mumbai.
Mumbai.
It falls under Western Railway.
Okay, then
And my lord, in that case, my lord, the consignor had offered a indent, my lord. He placed an indent and he sought for 42 wagons for this loading, my lord. And against which
what was the destination?
destination is, my lord, it's in NF Railway. That is at, my lord,
It doesn't matter. It comes within this sector, NF railway sector.
yes,
Yeah.
NF Railway. Thereafter, my lord, a wagon registration fee was collected and the entire 42 wagons were supplied to the party, my lord. Thereafter, he loaded the consignment and the consignment was moved from the booking station Chirai and it was destined to the destination station, my lord. And prior to loading, my lord, the forwarding note was executed and it was the freight was calculated based on the train load class, which is 100. But my lord, at the time of issuing the railway receipt, the railway had collected the freight. Instead of freight, my lord, they also collected additional freight based on the calculation, which is work out my lord, instead of train load class, they have collected in wagon load class. So which is a violation of the contract, which is executed at the
That
time
is
of.
at a higher rate.
Yes, my lord. Now, my lord, we just rely upon this railway board circular dated 5/6/2015, where, my lord, we
How
have,
much is your claim amount?
it's 22,57,444.
Reject.
It was rejected, my lord.
Madam, you get the instruction.
After 6 weeks, your lordship, it has to come from Mumbai, your lord.
We'll try to fix the date after 6. Okay. Heard MS Sharma, Leonard Council for the appellate who submit that the appeal was admitted on 16/6/2020 and LCR called for
Yes, it's very
and
possible.
and in compliance with the state order from the LCR has been received.
Yes.
MSK for
Also,
anesthesia is present for the railways and prays for some time to have the detailed instruction which would come from Mumbai. Not
As well as from NF Railway.
which should come from NF from the office of the NF Railway as well as from the Western Railways at Mumbai. Full stop. See according to this sometime. MS Sharma is the counsel for the appellant. However, submits that there is urgency as a huge amount of money is involved, which has been rejected by the tribunal without taking into account the relevant factors. Considering the above, that this matter be listed after
6 weeks.
6 weeks. Full stop. It is, however, made clear that that on receipt of the instruction, this court would take up this matter personally.
my lord, kindly a date may be fixed, my lord.
After 6 weeks, it may not be very easy, but tell us. Registry may list this case. Today,
Today is my lord, 5th August.
we'll have it on 18th of September. Is it okay?
18th is Monday, my lord. Kindly, can it be on Tuesday, 19th?
Monday, no problem. Okay, Tuesday, 19th. 99.
Deeply obliged.
So we scheduled appeal by the claimant for enhancement loss.
Somebody has died.
Right, death case,
How much is it?
award was given, your lordship, 20 lakhs, because the deceased for 2 years, he was under coma. He underwent treatment for 2 years here in Guwahati. They are
This
from
is the
Lucknow.
husband of
No, he's son of the,
one of the claim.
only son of the claimant,
Was
only
he
son.
doing something?
lordship.
This is was doing something or what? Was he working?
No, he was a businessman,
Businessman.
but the court rejected the evidence of the mother, and court
What was-
held that it was taken the national income as 6,000 something, 500.
What was the age?
He was age 35 now.
35. What
35.
business did you was it
He
doing?
was bamboo business, he was doing, your lordship.
Any
but-
of the evidence?
Bamboo business, but only the mother's statement was there. So, your lordship, my case is this, your lordship. So for the business is concerned, his income was not taken as a semi-skilled worker. At least that income ought to have been
But
taken
what
as.
was the evidence? You did not reduce any evidence.
You
Simply
know,
the
see,
mother's statement.
Your
He
mother,
was he an income tax assessee? No.
no, he was not assessing.
And some other person, his fellow businessman, somebody who has dealt with him.
the mother, because your lordship, only mother was there.
Because see,
and
35 years is an age which may come to your favor. He is not 20 years. That businessman cannot be, but 35 years businessman, it is very much possible. But only that you should have at least reduced some evidence by some of his colleagues, fellow businessmen, or somebody who has done business with him.
Apart from that, your lordship, the mother, they are from Lakhimpur. Mother was here 2 years for her treatment in the hospital, and nothing was given to the mother.
Really, you know what are the other what head?
Yes, I'm
You
saying.
know what are the head?
No, other head, other
Has
head.
have to be directly proximate to the treatment.
Apart
This
from,
somebody coming saying here that has to be reasonably done.
and that I'm coming on.
It should be a
So far the treatment is concerned, the claim was
How
for,
much are you claim?
I have claimed 20 lakhs for treatment, your lordship, but it was given 10 lakhs 62,000. 2 years he was in hospital in coma.
And what is the total amount you are paying?
I am claiming, your lordship, 30 lakhs, 60 lakhs in this case. And your lordship, apart from this, your lordship,
Okay,
interest was,
let us First appeal, is it?
Yes, it is, yeah, 173 appeal, Your Lordship.
Heard. PKJ. For the appeal, for the appellate payment. Who has heard this appeal? The section 173 of the FA Act. For of an award by the learned MPC Kamrup bracket F dated 2/5/2023 in MPC case number 2340 of 27. For the administrative number 2. It is submitted that income that the Senate tribunal had earned in some of the and had taken and had overlooked the aspect that for 2 years from the disease was in a stage of coma
In the
And-
hospital.
in the hospital at Guam, and the appellant failed from Lucky had to stay at Guam for this period during that admit for that step be taken for service of office upon responded by usual process as well as by registered proceed. Step by Monday.
That's all.
Lordship, this
Yeah.
appeal preferred by
Caveat.
the appeal preferred by plaintiff's appellant.
Caveat in the second appeal.
Lordship,
There is the earlier round of litigation, RSA was there, Lord.
Lordship, there are four judgments.
Even if it without caveat, we are going to dismiss the appeal.
Lordship, there are four
Where-
judgments.
Why are you wasting your effort?
Lordship. There are four judgments, three against us, one is in favor of us.
Now we want to have it.
Lordship, we have a very good case.
You want to have 4-2 now.
No,
There will be 4.
Lordship, yes, Lordship. Here is the case. Our exhibit 1 and exhibit 3 was rejected.
Who are you? Plaintiff.
Plaintiff. Exhibit 1,
Suit for
practical interest and confirmation of position.
confirmation.
Confirmation of position.
Suit dismissed.
Trial court dismissed it. First appellate court allowed the appeal. Against that, they preferred second appeal. In the second appeal, it
Remand.
was remanded for this purpose of reassessing, re-hearing on the point of exhibit A and exhibit 1 and exhibit A. Exhibit 1 was duly proved. It is original document, 30 years old document, proved by calling that official witness also. Official witness has given as per section 90 as well as section 60 of Registration Act. However, the exhibit A, which they
See.
produced,
You have said 1 and 3.
exhibit 1 and 3. Exhibit 2 or 3 is also proved, duly proved. However, exhibit A was a certified copy. There was no pleadings that this is a certified copy, and that was not proved. The learned court below, first appellate court, took up that exhibit to the correct document and exhibit 1 and 3 to be not genuine one.
2 and 3 are certified copies of what?
Exhibit A was a certified copy, whereas 1 and 3 was a original copy.
Of what? Copies
Certificate
of what?
registered seal.
Same seal deed.
Registered seal deed.
Same seal deed.
Lordship.
No, Lordship.
No,
A-
there are
A
three,
is
it was
our sale deed, Lordship, one is their sale deed.
Seal deed.
So let us come back. will comment. It- it-
Please start. Sir.
One. Yes.
It is your lordship. Lordship, this FAO has been taken up yesterday and it was admitted. But there we didn't file the stay petition for staying the operation of the impugn order dated
Your name Devi, D Devi,
D Devi.
but D Devi learned counsel for the applicant, the appellant, who by means of this application filed under order 41 rule 5, the CPC has prayed for stay of the order dated 3/7/2023 passed by the learned additional district judge FTC Pathar Silchar in title appeal number 4 of 2020, as well as for stay of the proceedings of TS number 37 of 2017 pending before the learned. Which is the original court?
Civil Judge 1. Sonitpur, Tejpur.
Sorry.
Kachar.
By the learned civil judge 1, comma,
Civil
Kachar,
Judge 1 is late, I
Kapara.
think.
The appeal has been preferred against the aforesaid order dated 3/7/2023, by which the first appellate court had remanded the matter for remanded the matter to the trial court for cross-examination of the DW1 and for any additional evidence in defense. The appeal has been admitted by the order dated 4/8/2020. It is submitted that the application was filed under order 41/27 for allowing adducing evidence at the appellate stage, and without fulfillment of the precondition, comma, the matter has been remanded. After hearing the party, after hearing the learned counsel for the applicant, this court is of the opinion that a case for passing an interim order is made up. According to my direction, that till the disposal of connected FAO 44 of 2020, comma, the impugned order is a 3/7/2020 passed by the learned district judge No, not district, additional district judge. Court edition. Qatar. Silchar, the title appeal number 4 of 2020. As well as the proceeding entitled suit number 37 of 2017 before the learned civil judge number 1.
1.
Qatar shall remain suspended. I tell
Obliged.
May it please capture. As per office note dated service report awaited for respondent number 2.
Mr. Das is for the railways.
One, my lord. No, it appears, my lord, RDP also filed something for appearance, perhaps he appearing for respondent number 2, my lord.
RDP.
Yes, last page. In that-
RDP is for CGC.
Yes,
Who is respondent number 2, madam?
my Eastern Railway.
Eastern Railway.
Oh, I think he has appeared.
Yes,
Name shown or not? So
shown, my lord. Therefore,
let us
since
have it
not
on,
there-
let us have it on
Right.
next week.
Yes.
If she appears, well and good. Just, Mr. Das, you try to inform her
Sure, my lord.
and you try to have the instructions. of
On the
her.
last
Right.
date also service report awaited for respondent number 2.
No, if
That
she is
may be
appearing,
clarified.
Yes,
let
sir.
her enter. There is an office note dated 31/3/2021 that neither unserved notice nor AD card has been received back. So far as service for respondent number 2 is concerned. Respondent number 1 is represented by Sri B.K. Das. Learned counsel. Was this, I would also reflect the name of MSRDP. Full stop, para. Reflect, however, full stop, however, comma, she is not present in the court today. Full stop, para. List on Wednesday next. To enable MS Devi to appear.
Obliged.
Obliged.
No, to enable her to give another opportunity for MS Devi to appear.
Obliged.
Please, Lordship.
Yes.
Lordship, as per office note dated 26 June, the service is awaited. The LCR has been completed.
Your name?
M. Kalita.
Priyam Kulita Learned Counsel for the
Appellants.
appellant. One appellant,
Yes, Lordship. Two
appellant
appellants.
has referred to the office note dated 26/6/2023, which reflects that LCR has been received, but neither AD card nor unserved notice upon unanswered notice so far as the respondent numbers 1 and 2 are concerned have been received back. Full stop. Office note dated 2/3/2023 indicates that notices by registered post with AD upon the state respondent numbers 1 and 2 was issued on 2/3/2023. Full stop. Para. Restricted list is for the learned laws in Oxford to pass appropriate orders on deemed service upon the state respondent and thereafter raise this matter.
Lordship, there is an IA. So kindly consider the intent.
I for
I for stay. I number 1991.
the returnable date. In the IAU, right? Interim order passed earlier. It's really correct. I will be that. Interim order passed earlier. Stands extended till the next date of it. should check it.
My
Yes,
Please, your
Mr.
lordship.
Mishra, what is this?
My lord, as per office note dated, my lord, 18/7/23, my lord, there is a office note, my lord, which says that notice have been written, my lord, with a remark not found at the given address, my lord.
Insufficient RTS.
Yes, ma'am. There are two notes, my lord.
Could not be served. He was not found at a given address, having left the rented house. Yes, what do you do now?
No, I will collect the fresh address, I will take fresh step, my lord.
There is an office note dated 18/7/2023, as per which notices upon the sole respondent,
My lord,
sole respondent could not be served due to insufficient address as well as the fact that the respondent has been reported to have left her earlier address of Sarah. Mr. The learned counsel prays for and is granted 3 weeks time to obtain instructions on the correct address, on the present address of the respondent. Please serve for 3 weeks.
oblige, your lord.
Lordship, I may be allowed to take fresh step, Lordship. Because there is office note which says that the AD card has returned, but there is no signature of the respondent. Lordship can place it to the Lavajima court.
Where is the award?
Lordship, it is against the order under section 9.
You were the claimant.
Yes, your lord.
Claim has been dismissed.
Yes, no, your lords, we have filed the we have filed the application under section 9, your lordship, seeking interim measures. Lordship, that has been dismissed, lordship.
That's been rejected.
Yes, your lord.
Your award has been passed on.
Lordship, I'm not fully sure of that.
What are you doing?
Against?
Has received.
Yes, your lord.
This is 3/8.
Sir, lordship, LCR has been received, but the respondents have not appeared.
Received with the state
I pray
the
for
seal
taking
and
fresh step, your lord.
and LCR, the AD card has been received back. Why
Lordship,
reported?
but there is no endorsement, lord, no signature, lordship.
There is a seal.
Yes, only seal is there. That's what on the last occasion also, lordship.
This is there. That is enough. Where is this? Green. as per office note dated 3/8/2023, healthier has been received. Full stop. Earlier office note dated 24/5/2023 reflects that AD card regarding the sole respondent has been received back with a seal. Full stop. Service is held to become held to be complete. Let this matter be listed for
Hearing.
this yet to be admitted,
What is statutory appeal?
not been admitted. Notices has been issued
Yes, sir.
for admission after 2 weeks. We'll admit it for this for here.
Lordship.
Yes,
Your lordship. As per office note, lordship, copy has been served only respondent number 2. Then number 1.
you have to take first steps upon one. Take the address. Yes. We grant you time, try to have the fresh address. New address. Office note dated 26/7/2023 reflects that two respondent number 2 has been served. Comma. Service could not be completed upon the respondent number 1 as the state respondent could not be located. Your name?
B. Datta.
B. Learned Counsel appearing for the applicant appellate. Raised and is granted 3 weeks time to obtain the present address, present public correct address of the respondent. List of the